Here I have summarized the main obligations related to your internal reporting channel. So first of all, you can have a written channel that can be a full-blown online system where breaches can be reported, but it can also be a simple mailbox, or even people can send a letter by post, or you can have some oral solution where people can call to a whistleblowing hotline. And also the whistleblower can request a personal meeting if he wants to explain his breach. Then very important, you have to safeguard the confidentiality of the whistleblower as much as possible and only disclose the identity of the whistleblower if it's really necessary and proportional. It can be mentioned that anonymous reporting, that's something that's not foreseen in the directive, which is quite logical. If you cannot protect a person, and this is actually the scope of the directive, the protection, if you don't know his entity, but it is optional and you can foresee an anonymous reporting in your internal reporting channel. Then very important is the duty of feedback. So once there is a breach reported, you have to acknowledge the receipt within 7 days. And you also have to provide feedback to the whistleblower on the actions that you have taken, the investigation and the outcome within 3 months. After 3 months, of course, the feedback can be that the investigation is still ongoing, but then it is expected that within 6 months you give an additional feedback on the outcome. Then you have some responsibilities regarding the governance of your internal reporting system, which means that you have to designate an impartial person or department to follow up on the alert and to do a decent investigation. So that has to be an impartial and a competent person. And the directive mentions, for example, that could be the compliance officer, HR, the legal counsel, the CFO, or an executive board member. And of course, this can also be outsourced to an external party. Then another requirement, which is quite logical and to be expected, is that you have to best data protection possible. So you have to secure the reporting channel, but also secure the storage of data afterwards on the breach, the actions taken, the outcome, and so on. So everything has to be GDPR compliant. Then you have a duty of information, which means that you have to communicate about your internal reporting system and process, but also on the fact that there are external reporting channels. And that's something that has to be made available, not only to employees, but also to suppliers, service providers, and other business partners. Then one of the key elements is the protection of the whistleblower. So he will be protected against retaliation and against any liability. So he should not in general be liable for the fact that he would disclose some confidential information when reporting a breach. And the retaliation is very broad, so it can be a dismissal, but also missing a promotion, or even not receiving any training anymore within his company. And very important, there is a reversal of the burden of proof. So if a whistleblower would, for example, not receive any training anymore after his reporting of a breach, then it's up to the employer to prove that that is not related to the fact that he is a whistleblower. So it's not the whistleblower that has to prove the negative impact. It's actually the employer that has to prove that there is no negative impact. And then a final, but also very important point is the protection of the person concerned. So the person that is being reported as possibly committing a breach. The identity of that person has to be protected as much as possible. And he has also some basic rights. So like for example, the presumption of innocence, the right to defend himself, to be heard, to have access to the investigation file, and a fair trial. So actually you are obliged to do a decent and proper investigation in an objective manner, and that person is aware of that and is involved in the investigation.